Welcome everyone. We'll start in a couple of minutes. Just to let you know, we're just waiting for everyone to join. Thank you. Good morning, everyone. Thanks for joining. We'll get started shortly. We'll get started in a minute. Good morning. We're still waiting a couple of moments rather than minutes for everyone to join, but we'll get started shortly. Good morning. We're happy to have you here. We're just waiting a couple of moments and then we'll get started shortly. Good morning, everyone, and on behalf of the Oxford Migration Studies Society, welcome to the annual conference and to our fourth panel on border discrimination. My name is Sarah, and I'm the co-president of the Oxford Migration Studies Society, together with Bella, who is in the background tech support team this morning. Thank you so much for coming. Border discrimination is the panel that I've been particularly looking forward to. We'll discuss different forms of border discrimination, both more legal and more activist perspectives, even if I surely don't want to suggest that these are mutually exclusive. I just wanted to take a moment at the beginning to flag some logistics before introducing the others on your screen. After the panelists have presented, there will be a Q&A. Please feel free to type questions into the Q&A box as you think of them, with the name of whoever the question is directed to, if that's applicable. You'll also have the choice to upvote and comment on each other's questions. And now I'd like to introduce you to your chair, Dr. Billy Holzberg. Billy Holzberg is lecturer in social justice at King's College London. His current research analyzes what role affect and emotion play in reproducing and contesting the European border regime. This book project centers around the concept of effective bordering and draws out the effective dimension of contemporary border politics through a close-up analysis of the long summer of migration of 2015 in Germany. Billy holds a PhD from the Gender Department of the London School of Economics. He was a postdoctoral fellow at the Sociology Department of the LSE and a visiting researcher at Columbia University in New York. His work has been published in journals like Body and Society, Sociology and International Affairs, and he just finished co-editing a special issue on the sexual politics of border control that will be published in Ethnic and Racial Studies. And I will take Billy from here. Enjoy. Thank you.
Yes. Thanks so much, Sarah, for the really nice introduction. I'm really excited to be here today, to be chairing on this fantastic panel and to be part of this really exciting conference. And it's great to see so many attendees here today. So this panel today will be on the concept of border discrimination. So we're going to tackle the discrimination as a core feature of how border regimes operate today and talk about questions of deservingness, desirability, and credibility from different perspectives, in particular also thinking about how questions of race, gender, and sexuality work through and in these forms of border discrimination. I've got 5 fantastic speakers here today. So we've got Dr. Catherine Briddick, Dr. Brandy Cochrane, Lotte Wolff, María Ramírez, and Rui Marquez Pinto, who I'm all going to introduce in more detail once we get to the actual papers. Okay, so without much further ado, I then want to start with the first paper by Catherine Briddick, who is the RSCS Martin James Departmental Lecturer in Gender and Forced Migration here at the University. She is principal investigator of the Undoing Discriminatory Borders project. And Catherine's work has been published in journals including Social and Legal Studies and International and Comparative Law Quarterly. Her co-authored chapter on trafficking and refugees will shortly be published in the Oxford Handbook of International Refugee Law. And Catherine has also practiced as a barrister representing individuals before courts and tribunals, in addition to having managed legal advice and information services in the not-for-profit sector. So today, Catherine is going to talk about when do migrant controls discriminate against women under CEDAW, which is the Committee to End All Discrimination Against Women. Right, welcome, Catherine. The floor is yours.
Thank you very much, Billy. And thank you very much, Isabella, Sarah, Magda, and everybody at OMSS, whose labour, seen and unseen, makes wonderful events like this possible. So I am going to be discussing discrimination in migration law. I hope you have my presentation now. Thank you. So the first thing I want to just ask is why discrimination law at all? The laws and practices that illegalize migrants' journeys create a regime of impunity for their deaths. Those are not my words, but the words of the UN Special Rapporteur in his report on the unlawful deaths of refugees and migrants. Now, his report is a very detailed analysis of the different ways in which states' migration control and deterrence practices produce deaths, tens of thousands of deaths, in fact. And one of the spotlights of his reports was the Mediterranean. But even detailed pieces of legal analysis like this fail to recognize that the laws and practices that produce the deaths of thousands of Africans, for example, in the Black Mediterranean, are racially discriminatory. And that failure is just one example of international law's racial aphasia. And here I'm quoting from the work of Saussure and Woods and Deborah Thompson. Now, this failure to speak of discrimination in migration control has particular racialized, but also particular gendered consequences. Women also face an increased risk of death when they undertake illegalized journeys, and it's a huge privilege to be on the panel today with Dr. Cochrane, whose research on the increased risk of death that women face at every stage in their journey from country of origin to country of destination has been very foundational to my own understandings of those topics. So we need to understand that these regimes don't just violate individuals' fundamental rights, such as the right to life or the right to be free from inhuman and degrading treatment. We need to understand that discrimination is one of the key wrongs here. You need to understand the nature of the wrong if you want to establish its appropriate remedy. So as Billy said, I'm working on a project on discriminatory borders. We know that migration controls intrinsically distinguish between nationals and non-nationals. That's one of the core aspects of sovereignty. But they also distribute the opportunity to move legally and safely in ways that are directly and indirectly discriminatory on a number of protected grounds. And what the broader project is looking at is the circumstances in which such distributions are unlawfully discriminatory under national, regional, or international law. The research that I am going to be briefly introducing to you today will be published later in the year in the American Journal of International Law. But if you're interested in issues around discrimination in migration law and control, we actually have a special issue that we're working on now with Dr. Shreya Atre and Professor Michelle Foster, the call for papers of which is currently being circulated. So do think about contributing your own research. So I'm looking, as Billy said, at the UN Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW Convention. And I'm looking also at the role of the committee that oversees it, the CEDAW Committee, a human rights treaty body. I'm asking two questions. The first one is around the circumstances in which CEDAW's general prohibition of discrimination can be used in the migration control context. The second question is more specific, and it looks at when states are challenged by individuals under the CEDAW optional protocol, what outcome those challenges have for individuals who are concerned or who allege that their rights have been violated. So there are two parts to this research. The first concerns interpretation. So I'm trying to establish the detailed obligations states have under CEDAW and its prohibition of discrimination in relation to their migration control practices. The second part of the research is around implementation. Having ascertained the detailed standards, I want to understand how those standards are applied to states and with what consequences. So before I introduce you to the core argument, I just want to say something about the structure of the convention. CEDAW starts by defining discrimination against women. It then prohibits it in Article 2 and has a series of substantive protections, including on trafficking, for example, and the right to a nationality. CEDAW's definition of discrimination against women in Article 1 includes violence against women under General Recommendations 19 and 35, but importantly, it applies to all human rights. So it applies to the rights protected by CEDAW, but also the rights in other international instruments. So it's a freestanding right to equal treatment, specifically the rights protected by the Universal Declaration of Human Rights, but not exclusively. And this is absolutely vital because key international instruments concerning migration and forced migration do not prohibit sex discrimination. So the Refugee Convention and the Statelessness Conventions, for example, prohibit discrimination on other protected grounds, including race, but don't prohibit discrimination on the grounds of sex or gender. The core argument that I want to introduce you to today is that my research reveals and starts to map a particular kind of deficit, a deficit of responsibility, a gap between the determination of states' obligations in the context of migration control and then the application of those standards to states. And I'm particularly concerned that the committee approaches migrant rights in the abstract in one way, but then when confronted with a particular rule or practices that is, by reference to its own materials, discriminatory, fails to hold states to account for their unlawful discrimination against women. So the first part of the research, as I said, was around mapping states' obligations under CEDAW. And so to do that, I reviewed all 38 of the committee's general recommendations. And the core set of findings I have from this is that the CEDAW committee has a very expansive definition of discrimination. And it uses that to identify unlawful discrimination against women at every point in women's journeys. In addition to breaching the Convention's general prohibition of discrimination, discriminatory treatment may give rise to an additional set of rights violations, because discriminatory treatment is not only a wrong in and of itself, but it also increases women's vulnerability to other forms of harm, including gender-based violence and particular forms of gender-based violence, including trafficking. Through these 32 recommendations, some of which are migration specific, but some of which are broader, the committee establishes a detailed set of mostly reinforcing obligations. And these obligations also contain recommendations which require states to reform indirectly discriminatory rules, abandon discriminatory practices, provide gender-sensitive determination procedures in relation to refugee status determination, for example, and apply gender-sensitive interpretation of relevant international conventions. Most importantly, in recommendation after recommendation, the committee urges states to make migration safe and accessible to all women on an intersectional basis. And specific rules impugned, for example, in relation to indirectly discriminatory rules, include things like tied or dependent visas, minimum income requirements, language or integration requirements, any requirement that makes it harder for a woman to acquire, retain, or obtain a safe rights bestowing migration status is identified by the committee as indirect discrimination that requires a remedy. Now, I don't have time today to go through all of these recommendations, but I just want to highlight a few examples from a very important recommendation on refugee protection. So recommendation number 32 specifically interprets Article 2 of the CEDAW Convention, the prohibition of discrimination that I've talked about so far, but it also provides a gender-sensitive interpretation of the Refugee Convention and then the conventions on statelessness. And as I said, this is important because those conventions don't contain in and of themselves prohibitions explicitly of sex discrimination. Nor, for those of you who are familiar with refugee law and the refugee definition, do they have sex, gender, or sexual orientation as convention grounds that give rise to a claim for refugee protection. So having gender-sensitive interpretations of those conventions, and very importantly, putting in place gender-sensitive determination procedures are vital to ensure that women are appropriately recognised as refugees. And the committee makes kind of very broad comments in the recommendation around things like credibility, internal relocation and the refugee definition, but it also makes a series of very detailed and specific recommendations about RSD procedures, including, for example, that refugees should be entitled to female interviewers and interpreters, to childcare and RSD processes, to counselling, legal advice, legal information, and representation. Overall, the recommendation requires states to ensure that protection-seeking women have their claims determined in a system that is informed in every respect by a thorough understanding of discrimination, persecution on the grounds of sex, gender, and the impacts of such treatment. So having given you a sense of the interpretive role of the committee, I now want to shift my lens and take you to the second strand of the CEDAW committee's work, its adjudication of individual communications under its optional protocol. So having reviewed the general comments, I am now focusing on a 10-year period of individual communications, and I've identified 30 that relate to migration control. And the first striking thing about these communications when you work your way through them is that the breadth of CEDAW's thinking on discrimination in the context of migration control is simply not reflected in those communications, which are both geographically skewed and substantively distorted. And just to give you a sense of that, there are, I think, 119 parties to the optional protocol of CEDAW. So that's 119 states that have signed up to this complaints process. However, there are more relevant migration cases brought by one or represented by one man in Denmark than from the remaining mostly European countries who brought cases. So there's a significant geographical skewing to the communications brought. Also substantively, although CEDAW committee talks about things like tied visas, as I've mentioned, minimum income requirements, pushbacks, and other discriminatory laws and practices, the cases in the period that I've looked at overwhelmingly concerned with non-refoulement, so return. They were overwhelmingly found to be inadmissible by the committee, and of the 8 that were admissible, there were only 3 in which a breach was found. And I just want to talk to you today about one of the cases that I'm reviewing, because I think it's illustrative of this responsibility deficit. So you will recall the standards in General Comment 32, which are very detailed when it comes to how states should determine refugee claims and have a gender-sensitive interpretation of the Refugee Convention grounds. So in FHA versus Denmark and in case after case, however, the committee applies a different standard to individuals who bring their communications. And what the committee says is that it's generally for the authorities of state parties to the convention to evaluate the facts and evidence or the application of national law in particular cases, unless it can be established that the evaluation was biased based on gender stereotypes or which constitute discrimination against women or were arbitrary or amounted to a denial of justice. So there is a very simple mismatch between the standard that applicants who want to complain about discriminatory treatment to the committee have to reach through the individual complaints procedure and the standards articulated in General Comment 32. And indeed, when it comes to individual complaints, the committee applies this same standards before and after 2014, when the General Recommendation 32 was issued by the committee. And that raises just a very basic question, which is, well, does General Recommendation 32 make any difference whatsoever to the situation confronted by migrant and refugee women? And just one example of this can be pointed to in FHA versus Denmark, and that's on gender stereotypes. So as I said, the committee says it won't intervene with a state's decision-making in a refugee case unless it was biased or based on gender stereotypes. But in this case, FHA, gender stereotypes were referred to. So in paragraph 3.1, when summarizing the facts of the case, the committee refers to the fact that if the applicant, a protection seeker in relation to gender-based violence, forced marriage, inhuman and degrading treatment, that she could or may have access to a male support network. And this is a statement that's made in the communication that isn't challenged by the state and isn't challenged by the CEDAW committee itself. And what that indicates is that the committee thinks it's acceptable or potentially acceptable that women who flee gender-based or patriarchal violence should first turn to the patriarchy for protection from it before seeking international protection. Or indeed that the potential accessibility of such protection might go to the question of whether or not there is a sufficiency of protection available to the woman in the state from which she has fled. Now, this to me is simply unacceptable. It forms no part of the Refugee Convention definition, and even in cases where states and others argue that non-state actors may be able to provide protection in certain circumstances, that protection is generally not considered to be available from those sources of harm to refugees and other protection seekers in the first place. Even if that argument was potentially runnable in a refugee law case, it's not something that the CEDAW committee should find acceptable or should give any space to whatsoever, particularly given that CEDAW has issued 2 general recommendations on states' responsibility to protect women from gender-based violence, including that violence that is perpetrated by private actors, so such as partners, friends, or family members. This case is illustrative of the cases that I'm looking at in the 10-year period. Another case that's particularly concerning is MEN versus Denmark, where impunity for rape that was committed by multiple perpetrators was not recognized as gender-based persecution or sex-based discrimination by the committee. And there's a very powerful dissent to that communication by Dubravka Simonovic, who is now the UN Special Rapporteur for Violence Against Women. So the cases that I'm discussing with you today are illustrative of a trend in the committee's jurisprudence on violence and discrimination against women. So to bring this presentation to an end, I have some tentative conclusions that I'm working through at the moment. Whilst the committee has put in place a matrix of obligations in relation to discrimination experienced by women in the context of migration control, its jurisprudence on this point is, I think, unprincipled. And in relation to refugee status determination, there's a significant protection lacuna. Asylum-seeking women are simply unable to claim the rights that are guaranteed to them in General Recommendation 32. The committee's using the Article 2 prohibition of discrimination in the Convention to fill legal and normative gaps in the international protection regime. So to speak to the silences in the Refugee Convention, for example, about gender-based persecution, about credibility, or sex discrimination in the enjoyment of the other rights protected by the Convention. And that's an important role that the committee has, an important norm-filling role in international law. However, it can only be successful in that role if it then holds states responsible for violating the obligations it has itself identified. Now, the things that I'm looking at the moment is trying to understand the causes of this responsibility deficit. in addition to kind of mapping its contours. And I think there are two things that I'm thinking about and that I'd be very interested in anybody's views on in the question and answer session afterwards. The first one is a question of institutional incompetence. Is this a problem of the CEDAW committee or of human rights treaty bodies more generally? And then the final issue is this a problem with discrimination law? Why does unlawful discrimination experienced in the context of migration control consistently and persistently go unremedied? Thank you very much.
Fantastic. Thanks so much for this really important intervention, Catherine. Going to move on to the next paper by María Ramírez. Before we do so, just a quick shout out because I forgot to say in the beginning. So if you have any questions, you can see on the bottom this little Q&A thing you can click. Just put your question there, and then we have time for Q&A at the end. We have about 30 minutes, and I will pick some of the questions for the panelists to answer then. Okay, so now we have Ana Ramírez, who studied political science at Pontificia Universidad Javeriana in Bogota, Colombia. And she first worked at the International Center for Transitional Justice, and then as a public servant at the National Center for Historical Memory. Before coming to London, she also worked at the Center for the Study of Law, Justice and Society, De Justicia, it's called, which is a think, do tank that focuses on human rights advocacy and social change in Colombia and beyond. In 2020, she graduated from the MDS Social Innovation from Ravensbourne University and currently is working for Citizens UK, engaging the Latin American diaspora community to tackle digital exclusion. And there she supports particularly the new website, is in charge of digital organizing tools and creating a new resource hub. She also collaborates with the Latin American parent engagement group, Empoderando Familias. And today, Ana is going to talk about dismantling digital borders, the experience of a Latin American parent engagement group during the pandemic. So welcome, Ana. Very excited to have you here. The floor is yours.
Thank you, Billy. Thank you all for being here, and thank you to all the help behind the scenes we've had in this process. I am now going to share my screen. Yes, so thank you. As Billy mentioned, I'm going to talk about digital borders and the experience of a Latin American parent engagement group during the pandemic. So what is Empoderando Familias? This Latin American parent engagement group. A few years ago, King's College created a group called Parent Power. King's College and Citizens UK created this group to support parents under the premise that when parents support their children adequately when they are teenagers, they might get better chances to go to college. Inside this group, Parent Power, we had a Colombian who I think is actually here. Hi, Lily. Lily thought that this was such a great idea that it should be replicated, but for the Latin American parents. That's why the group is done mostly in Spanish, and we meet and discuss the education system and how can we best support our children so they have better chances to going to college. But that what happened? We were just starting with our group. We were very, very excited, and the pandemic hit. As we know, last year was a very challenging year in general for everyone, but also for groups. We were just still consolidating, and we faced that question. What should we do? Should we stop, or should we move to digital? And we chose the second one. And this is when we knew, or when we understood, that we could not very much assume that everyone could just connect, and that we would just send a Zoom link and that everybody would arrive. And that's why we did like such an exercise to understand and identify the barriers that were preventing Latin American participants of our group to actually connect. Then I am going to discuss today as well what are those barriers related to, and finally, how can we facilitate or support this transition to digital. So what are some of the barriers that we identified in this whole process when connecting online. The first one, of course, is about connectivity. So it's about having good quality of connection or accessibility. So for example, for some that do have Wi-Fi in their houses, the internet might be too slow because too many devices are connected to one network. Then for some that used to have Wi-Fi, because of the circumstances and because of what happened, losing your job, getting less hours paid, being furloughed, not having any job at all, Wi-Fi was something that is now too expensive to have. So we used to have Wi-Fi, but because of the pandemic, we don't have anymore. And then for some that connect to the internet using their data plan, we all know a data plan is not enough. And it's not enough for the needs that aroused due to the pandemic. So first of all, connectivity. Then devices, so the number and the quality. So for some of the households, of course, it would be the best to have one device per person, but for some, they only have one device to connect. And in some of the cases, it's a mobile phone. Then, for example, some might have a PC or a computer, but it's an old one that doesn't have storage capacity to, for example, run a Zoom call. And it's all about devices, having enough and having good quality devices that can address the needs of today's situation. Then it's all about feelings when connecting, you know. For some, internet and connectivity was just intimidating, you know, and I felt ashamed because I didn't know how to do it, or I just felt overwhelmed. It's too much, it's too difficult, also anxious. But for some, it was something about feeling out of place, you know, like internet is not a place for me. It's more a place for those men in their ties in the city, but not necessarily for me. So it was all about building confidence and building trust when connecting online. Finally, of course, everything about literacy, knowledge, awareness even. So it's like, I just don't know how to do it. I just don't know how to connect. What do I do next? And also the awareness. So awareness about feeling, I don't need the internet. I just don't need that. So it was all creating this awareness within our members as well. Finally, this is in this graph, you can see the blue is when we asked them about how confident they felt navigating online. And you can see that we have a lot of blue in this graph, which is great. But then in this graph, the blue now turns very little, which is the confidence with the English language. And we very much identified that for some, the confidence browsing or connecting online is lost when you come across content that is in English. So, and English is very much a barrier when connecting or navigating online, at least for immigrants here in the UK. So are these barriers related to underlying structural inequalities? Yes, of course. We can very much explain some of this digital exclusion due to other things that happened, that emerged due to COVID or that exacerbated things as low wages and work instability, care work and unpaid gendered labor, domestic abuse, food insecurity, overcrowding and inappropriate living conditions. These are all things issues that lots of immigrants here face, the hostile environment and how it's very much connected, and how digital exclusion can be just a symptom of something bigger, something else, which might be very much connected to what we see in this slide. So what were some of the learnings during our last year and during our experience together? First is that we had reactive, now we need long-lasting measures relating digital inclusion. When the pandemic started, the lockdown, everyone was talking about digital exclusion and how we needed to take and give, but now we kind of have forgotten about it. And of course, these underlying structural inequalities that I mentioned in the last slide, causing the lack of connectivity, might still subsist and can even exacerbate during this post-lockdown or economic crisis that we might face now when the mobility restrictions are over. Also, we need to basically campaign for the right to broadband and connectivity. With everything that happened due to the pandemic, lots of different services, information, rights moved online. Financial, education, health are now provided online. And if we cannot access, because as I mentioned, Wi-Fi can be very expensive, if we cannot access this, we are basically not accessing a right, a basic right. So it's very, very much important to campaign for this. Also campaign for ESOL, so English to speakers of other languages. I don't have the official numbers because that's another thing, but the Latin Americans are not yet recognized as an ethnicity, not in the UK, not even in the 2021 census. So this is a shadow number, and only almost 50% of the Latin Americans immigrants living in London don't speak proper English. Last year, I went to a mental health summit and someone defined loneliness or isolation as not being able to be yourself, not feeling yourself. And I'm bringing this when I'm talking about English, because learning English as an immigrant is basically a very big challenge, because it means that you need to learn how to be yourself in another language, which might be a process that's very, very isolating, and where you might feel very, very lonely. And the women I've met here are very, very much motivated to learn, but it's not easy. You not only need your learning skills and motivation, but also time, practice, and money. And we saw some of these overarching circumstances that might not help in this process. So to end, this is basically our experience. We had a very difficult year, but we had a great year together. We met every week during the whole year that passed. And what we did basically is that we kept company. We were together. We were learning about the education system here in the UK. We were talking about mental health, self-care, and all of that while being social distance, not together, but yet in a same digital space. Thank you.
Great, thanks so much, Anna, for this really beautiful and engaging paper. I'm sure we can come back to some of the questions in the Q&A. So please, everyone, just put the questions in the Q&A box, and then we get there. Okay, so our next speakers are Brandy Cochrane and Lotte Wolff. So Brandy is a lecturer and researcher in criminology at Victoria University, and their current research focuses on border securitization and the refugee and asylum seeking community in Australia. Their research and teaching interests include gender, migration, security, methods, crimes of the powerful, critical and queer studies. And Brandy received a PhD from Monash University in 2017 and an MS from Portland State University in 2012. And Brandy is joined today by Lotte Wolff, who holds an MA in Development Studies from the Graduate Institute of International and Development Studies in Geneva. She has conducted research on LGBTIQ plus people seeking asylum, both in the Netherlands and Australia, combining queer theory with an interdisciplinary analysis of domestic migration policies and practices. She's particularly interested in the intersections of colonial history, post-colonial gender and queer theory, and migration governance. And today, Brandy and Lotte are going to talk to a paper entitled Knowable-ness, the unspoken criteria and refugee status determination for LGBTIQ plus applicants in Australia. So welcome, Brandy and Lotte.
Thank you for the introduction, Billy. I just wanted to start us off by acknowledging the traditional owners of the land on which we meet today. I'm meeting on the land of the Gadigal people of the Eora Nation, and I wanted to pay my respects to their elders past, present, and emerging. So our research is about people seeking asylum in Australia because of persecution due to their sexuality and or gender identity. So in Australia, the Department of Home Affairs conducts a refugee status determination interview to determine whether the applicant will fit into the definition of the Refugee Convention, which would be membership of a social group in this case, that would allow them to be granted a protection visa. So it is well established that having a credible narrative of persecution is one of the most important elements of being granted refugee status. Researchers have found that credibility assessment can be based on elements such as perceived trust and can be quite inconsistent between decision makers. According to the Australian Administrative Appeals Tribunal, the decision maker must make its assessment on the basis that it is possible, although not certain, that the applicant's account of past events is true. So credibility really comes down to two elements: the internal consistency of the narrative that's presented and whether that is externally consistent with objective evidence, which often includes documentation or information relating to their claim. Now, for LGBTI refugees, gaining protection rests on a credible narrative of both the persecution they faced and their LGBTQ identity. And whilst credibility is important for all refugee applicants, LGBTIQ+ applicants face an extra barrier because there's usually limited physical proof or documentation, so that external consistency of their story. And so their testimony will weigh heavily in the decision made. So we completed interviews with legal representatives in Australia that represent LGBTIQ+ people seeking asylum. They were recruited in Melbourne and Sydney in Australia. We did semi-structured interviews with them about an hour each and spoke to them about how they represent applicants in the refugee status determination interview and how those applicants can prove their queer identity and kind of the role that legal representatives can play in helping them navigate this whole very complex system. So when looking at the data that we had through a lens of credibility, so how do they construct a credible narrative of their queer identity? How do they prove their queerness? It struck us that there is kind of an unspoken aspect of credibility, and we're calling this knowable-ness. To be more likely to be read as credible, the narrative presented has to be recognizable or even familiar to the decision maker. All refugee applicants apply under specific grounds in the convention, and so must fit into an understood category, race, religion, nationality, that have explicit and implicit boundaries. The category, and therefore the applicant, is understood in a certain way by the decision maker. And we argue that it is easier to be understood in a category if the narrative portrayed is familiar to the decision maker. So knowability is the extent to which the narrative, and for queer people, this often means their identity, fits into the worldview of the decision maker. So Brandy will provide a few examples of this in practice, but broadly, our research found that queer applicants stand a better chance of being perceived as credible if they fall into certain stereotypical tropes and assumptions of what queer identity looks like. So for example, those that are living an out and proud life, if you want to call it that, are present in the queer community once they arrive in Australia and are living their queer identity openly, are more likely to be seen as credible. Other assumptions that we found are that applicants will be or will want to be in a relationship. So having a partner is seen as reliable proof of queer identity, and having a clear coming out story is another way that applicants can be perceived as more credible. And all these aspects align in some way to a traditional Western narrative of queerness. And the reality is that not all queer applicants have experienced this and can kind of recreate this in their refugee status determination interview. Importantly, applicants that have a fixed identity label, so one that doesn't change throughout the process, and can label their sexual or gender identity with a well-known Western label, stand a better chance of being perceived as credible. And this is one of the examples of how An applicant's chance of being perceived as credible is improved when their story aligns with versions of queerness that the decision maker already knows. I'll now pass to Brandy to continue.
Thanks, Lotte. Sorry about the technical difficulties at the beginning, everyone. So I'm going to talk a little bit about the misunderstood, which is kind of the next part of our paper, and it's to discuss those who don't quite as easily fit into, understandings within refugee status determination. And one of the things that was really interesting that we found was this idea of a bisexual experience. So the bisexual experience was confusing to refugee status determination adjudicators. People who are representing them found it really difficult to say, to discuss, why this is an important sexuality and why this matters as much as, say, being gay or lesbian. And, as you can see here from Max, we find that legal representatives often talked about, the hardest time of all, it seems impossible to get around, is to wrap their heads around the idea that someone's sexuality is what they claim, even when it doesn't fit in there, right? It is in this idea of this. And bisexual people actually have some of the hardest times fitting into the acceptability of their need for asylum. The other sort of pillar that we argue here is that there's also what we call the uncategorizable. And these are two, let's say, area-specific, geographic-specific groups. One of them being Peng kids, specifically from Malaysia, and one thing being from Tonga, or sometimes other parts of the South Pacific area as well, called Whakalati. And what we found is that when people didn't grasp on to a certain label or gender or expectation of how they should behave, that adjudicators you're confused, that we found that legal representatives wanted to help lead them into a more knowable category, which we'll talk about in a second. But what we found is there's, we have to, you kind of have to pick something, right, to be able to talk about that kind of persecution, and that has to be a knowable characteristic. So if you are someone like a Peng kid who, identifies as a Peng kid, right, someone who's a tomboy, somebody who may or may not, do chest binding, who dates women, but doesn't identify as a trans man, but doesn't identify as a lesbian, we have these sort of, categories that are outside of our knowledge of Western understanding. That when these kinds of people go up against refugee status determination, they are, at a disadvantage. And so that's what we're arguing about, this knowableness. If we can't, if the adjudicator can't get it, then they can't accept that claim. We also found the same with Whakalati. Forgive my white person pronunciation there, is to think, a little bit about, just because someone, there's this understanding of that there's doing drag, there's, but there's also transgender women, or someone who perceives themselves as fitting in a more feminine role. It doesn't have, our Western language doesn't make, a bit of sense there. And so, what happens is these kinds of people, Peng kids, Whakalati, there's also other examples that we came across, are doubly misunderstood. So what we're doing in this paper is attempting to start to theorize knowable-ness as perhaps a subsection of credibility, which is that if a adjudicator for refugee status determination, it's not just about your credibility, because part of your credibility is, can they understand you? Can they connect with you? And that's knowable-ness. And we argue that all asylum seekers actually confront this particular issue, but that it can be more complex for LGBTIQ+. And here, as you can see, we start to, think a little bit about, okay, if we have these scales of knowable sexualities and less knowable sexualities, and gender and less knowable gender, and how that might actually, interrelate to decisions that are made. So that's exciting. But then kind of the next step that we're taking in this particular article is, oops, going the wrong way in the presentation is the next step we're taking, is how legal representatives for these people step in and shepherd them. We're kind of using the term shepherding. I think I was maybe reading too much Foucault at the moment, but this idea of being shepherded into an identity that can be understood by the adjudicator. So, we saw, all these, legal representatives saying people should be able to have their own, identities, they should be able to have this, but we have to get them into a category that's knowable, or we can't get them refugee status determination, or instead, left out in the cold a bit if they can't find something to identify with. And as you can see from some of the quotes on here is, they talk a little bit about, we have to, number one, you have to explain Western labels to clients, but also we have to make them, not make them, but they need to choose one if they want to be able to seek asylum within Australia. And, I think our broader findings, will be that that's probably happens, in a lot of different places. But I think this is some interesting work that we're, currently working on around that. Oops, that is my problem tonight. All right, thank you so much.
Right, can everyone see me? Yes, now I'm back. Yeah, thanks so much for really interesting research and for sharing some of your findings on it. I really love the concept of the misunderstood and the shepherding. So I'm sure we can hopefully also have some time to talk more about that at the end. All right, and now last but not least, we have Rui Marquez Pinto here with us, who holds a master's degree in social work and human rights from the University of Göteborg. He's at the moment an independent researcher, and he was a political advisor for immigration integration at the Reutlingen municipality between 2015 and 2020. His job was to plan motivation strategies to increase participation of immigrants in Reutlingen's political life. With his political experience in 2019, he founded Demokratie Café, so the Democracy Café in Reutlingen, a think tank project that aims to bring together the private and public sectors, as well as politicians and civil society, to discuss the importance of democracy values in times of crisis. And Rui today is going to talk about immigration challenging meritocracy ideology between criminalization and justice. I think you have to unmute yourself. That's it. If I can find you. Yeah, I think now.
Okay, it's okay. Your PowerPoint is also, or?
Yes, the PowerPoint is also good.
Is good. Okay. Okay, thank you, Bill, for your kind introduction. Thank you all to be here. It's a great privilege and honor to be invited to speak in this conference. I would like, before I start, to honor the Oxford Migration Studies Society and partners to deliver this conference. I extend my thanks to the Lotte magazine editors team that correct my paper. My topic is the immigration challenge, the meritocracy ideology between criminalization and justice. I argue that criminalization is not just encompass borders, but also inside borders. Therefore, we will start to looking at rule of law through the lens of basic German law constitution as a guaranteed fundamental rights to equal treatment. And then we look to Article 1, Paragraph 1, Article 3, and then we reflect how law and race have a constitutive relationship, the ongoing dialect on formation of race and arm approach. Before conclusion, we reflect on what meritocracy has to do with the formation of the race, and finally the conclusion. Okay. The first point, the rule of law, the fundamental rights to equal treatment in German. The German Constitution, ratified in 1949 after the Second World War, and introduced human rights principles in its constitution. Article 1, Paragraph 1, that I quote, human dignity shall be inviolable, to respect and protect it shall be the duty of all state authority. The equal of human beings before the law is anchored in Article 3 of the Basic Law, that I quote paragraph 1, all persons shall be equal before the law. Men and women shall have equal rights. The state shall promote the actual implementation of equal rights for women and men and take steps to eliminate disadvantages that now exist. I quote paragraph 3, no person shall be favored or disfavored because of sex, parentage, race, language, homeland and origin, faith or religion or political opinion. No person shall be disfavored because of disability. Another important legislative measure are the 4 European directives: the Racial Equality Directive, the Equal Treatment in Employment and the Occupation Directive, the Equal Treatment in Goods and Service Directive, and the Equal Treatment Directive. All these directives have been incorporated into German law via the General Treatment Act, Allgemeines Gleichbehandlungsgesetz in German. The aim of those directives is to designate certain groups of people as requiring special protection, as well as to improve their integration into the labor market and to prevent or eliminate discrimination in the access to and supply of goods and service. All this has to do with the criminalization. This is my second point, criminalization through the lens of the constitutive dimension of the law and the race. I agree here that the race formation as a social construction rather than biological one will shape the attitudes before migration. For example, concept of the race or Race in German, a term that appears in the Basic Law and since 1949 has been not modified. Therefore, given German National Socialist past, question of race undoubtedly even cause even more discomfort when data show that the rise of discrimination, inequality and xenophobic crimes against migrants and refugees. Of course, in nowadays, this is more complex because the different phenotypes used to characterize migration that goes beyond the dichotomy black and white. And this appears in the German Annual Report in 2009, was edited by Federal Anti-Discrimination Agency, reports some types of phenotypes like, for example, I quote, I work in the hairdresser. One customer recently called out down the shop, where is my Negro? I like it best when he massages my head. The experience of a Syrian woman, I caught 2 men who work in the different department asked me laughing if I worked for the company as the woman who makes the coffee. She said she is a civil engineer from Syria, employed as a statistician. When I told them that, they laughed ever louder and asked if I worked to German or Syria standard. I outlined some of the harms that can come from this kind of result from discrimination. For example, physical harms, for example, harms involving injury or illness, financial harm out from the employment, in terms of the income, job security, psychological harm, mental illness or anxiety, cultural harm, that is for threats to cultural safety. To say that racial formation theory shows how law intervenes in the reproduction of race ideology and its key role in producing the racial order, as well as interweaving ideas about race with class-based stereotypes. This is what historian Manny Marabel, he was an American professor of public affairs, history and African-American studies at Columbia University, I quote, when he talks about race, not as a biological or genetic category, but rather as a way of interpreting the difference between people, which creates or reinforces inequalities among them. The third point, the danger of meritocracy system hardened and then we'll see the rule of law. I define rule of law here means the government official and citizens are bound by and abide by the law. Therefore, the government will enforce the legal rules when they are breached. These laws are overridden by the meritocracy system. How? Which defines fairness and prescribes individual roles to fit in the society ruled by merit. This is achieved through the discourse of individualism, all in this liberal standard, a discourse that posits race as irrelevant, obscuring how social positioning impacts opportunity. Therefore, it claims that we all act independently for one another and that have the same possibility of achieving our goals. Under the rule individualist paradigm, I say the ideals of fairness, individual competition, and the distributive justice depend on arbitrary interpretation of individual performance. I say here arbitrary, here means a manifestation of power that is not constrained by a suitable framework of law. For example, a colorblind policy. When we consider the German labor market before COVID-19, the rise of inequality, consequence of discrimination is usually explained with two factors. Discrimination, taste-based discrimination is due to taste of people, or what is referred to as preferences in economics. And the second is statistical discrimination based on the scarcity of information. I can extend more after in the discussion. Social scholars have been demonstrated that income and wealth inequality has increased at the same time that meritocracy political agenda has been embraced. Meritocracy beliefs goes hand by hand with greater economic inequality. They say this is not just a coincidental association. Meritocratic beliefs are not opposed to inequality, only to discrimination, which prevents people with the right merits from reaping rewards. We see some data from anti-discrimination department here in Germany. 2009, this is increased to 1,625 to 3,518. Trends in inquiries concern ground protects in the Guide to Gender Equal Treatment Act. 2008-2009, ethnicity or race origin was the most discriminate, to 31% to 33%. And we see the 2005-2009 trends in requests for counsel, May 20 discrimination against related to ethnicity. Racist discrimination also increased for 545 for 1,176. In conclusion, we could conclude that this intersection with law in the race compound racial formation on ongoing dialect with the meritocracy principles of merit and talent as paths to criminalize and neutralizing the rule of law through individualism arbitrary discourse. Therefore, we could conclude the meritocracy agenda transforms control factors like race, religion, nationality, and sex made through the legislations irrelevant. The law become neutral, increasing racism inequality in labor market, and this is the harm inflicted from this discrimination on vulnerable groups by meritocracy neutral rule of law. Let us to look on another direction of what crime is. Thank you very much for your attention and open for discussing.
Perfect. Thanks so much, Rui, for this really important paper. Yes, so that means we're at the end of the paper. So I welcome all the speakers to maybe turn their videos on again so we can see you. And now we have about 25 minutes for Q&A, and I can already see that been some questions coming up in the box. So I thought we maybe just start by looking at 1 or 2 questions per speaker. Yeah, and then we can see where the discussion goes from there. So maybe we start with a question for Anna. So Helia is thanking you for the great paper and experience, and is asking whether you only focused on mental health with your peer Latin Americans, and if you've seen the IRMO report. And I think in relation to that question, we also have a question by an anonymous attendee who is asking how you reach displaced communities who do not have access to internet and digital devices, and how you kind of deal with that question, and also where you see your program going in the next 2 years.
Thank you for all the other presentations. They were all fascinating, and thank you for these questions. So to start, thank you, Elia, for your question. I, of course, admire the work Irmo does. And yes, I've seen the report you're talking about, which is excellent, talking about the impact on mental health and how the pandemic impacted our mental health. So, of course, and we, because the group works very close or with Citizens UK, a few months ago, campaign, a listening campaign, South London Listens, started. It's a campaign to address the impact of mental health, the impact of the pandemic in our mental health. And because we very much wanted to involve the Latin American and the non-English speaking voices within the conversation, we did lots of exercise of just bringing our voices, our opinions, our stories, our testimonies to these exercises. And since then, we've very much been very active around the mental health issues. And of course, during the whole pandemic of self-care, in our group, moms, it's very important for them to take care of themselves because they're taking care of everyone but themselves. So of course, this message of mental health, but also self-care is a must and something that we almost every time discussed in our group. And now the second question, so how to access these people that are not necessarily connected, is of course a very difficult challenge. And what we did, we very much work with a community organizing method, and it's all about the one-to-ones and the building relationships at the speed of trust. So we basically with those people that were referred to our group or that we know of, we did a very close connection by talking in our phones, having in-depth conversations, getting to know each other, inviting them to the group. And we very much used a relational approach to tackle technology. So step by step, knowing what's the difficulty for each of the people who could not connect and why, and then trying to support them. Of course, there were a lot of things happening with digital inclusion, so making the bridge with the people the person that might have the need with someone that might be able to supply that thing that was missing, and basically that one-to-one and that relational approach to tackle technology and digital exclusion. I think that was like our secret on how we did it, and why I would say it was a very successful, because we were very much able to connect during these very difficult times. And our impact, of course, because we work on community organizing, our work is all about impact. And for example, we had one of our members, Ms. Lopez, Claudia Lopez, who I deeply admired. Citizens UK did the major London Assembly. So basically, they invited the two candidates, the two top candidates for the London mayoral elections, and we did with our asks, and the now elected London mayor said yes to ESOL, to having a staffed and a current page of English. So we had Ms. Lopez there talking one-to-one to him. So it's just all about the impact, you know, and creating leadership amongst all of us during this process.
Fantastic. Thank you, Anna. And then we've also got some questions coming in for Rui. So your concept of taste-based discrimination seems to evoke a lot of interest. So Ingrida is thanking you for the fascinating presentation and the concept of taste-based discrimination that is very timely and spot on. But Isabel is asking if you could expand on it a bit more, maybe because they are unfamiliar with the concept. And it seems to be one that seems to strike a chord with the audience. So if you want to speak to that.
Okay, thank you for the questions. I will say that the Rooted magazine editors, they have the part from the papers edited. They could expand, but because the scope of the time here, I didn't go in the details, but basically this is so. The taste-based discrimination, I will consider, for example, one example, hypothetical case of an employer who needs to make hiring decisions and is faced with two employees, one from majority cultures and the other from minority culture, who have the exact same CV, the same expected future productivity, the same expected team spirit. If the employer would still choose to hire the majority person, then this means he or she has the taste to do so. This means the taste-based discrimination refers to discrimination that is due to the taste of the people, or what is referred to as preferences in economic or social economic status. In the case from statistical discrimination, this is so in context of behavior uncertainty. In such context, individuals do not know how certain person from minority groups will interact or will behave in the context from the labor market. Basically, this is just so I could say to explain the difference between tastes. Of course, these two kinds of discrimination in labor market is very important that I didn't have time to explain. Very important for policymakers to recognize and also to implement developments to tackle discrimination. For example, if discrimination requires taste-based discrimination, for example, means that the policymakers be aware from this taste, they have to implement another statistic. Let me see if I can find here one example. Okay, for example, provide for statistical discrimination can overcome if the employer has much accurate information as possible as about the specific employees involved. So overcoming the taste-based discrimination instead should deal with influencing preferences of people and most likely requires something more than provision of information. Basically, this is what I have here to explain. Of course, there is a lot of research that explain much more in details about.
Right, great. Thanks so much, Rui. And then we've got lots of questions around best practice for Catherine. So an anonymous attendee is also thanking you for an amazing presentation and asking that I'm working on the CEDAW implementation in Southeast Asian region. May I know how to advocate for the protection of the women, children who informally enters the host country and currently are living under the shadow of illegality? And the second part of my question is, how do we ensure the protection of women and girl migrants in the migration which are mostly illegal and do not fall under monitoring radar? And Ruth Ramirez similarly asked, may I know what are the best practices to provide safety and protection for informal migrants who reach the border of the host country?
Thank you very much. I'm now going to move from kind of academic analysis to practitioner mode, because having talked about the problems with the CEDAW committee and its work, I'm now going to tell you why the CEDAW convention is really useful to deal with issues around migration status discrimination and the issues that the anonymous attendee raises. So the first thing is, you don't say which country you're from, and that's really important to know as an initial step. If you want to work out how you can use international covenants to enforce migrant and other people's rights, the first step is to work out what international conventions a particular state has signed up to, has ratified, and also what optional protocols it has acceded to. And there's a UN treaty body website, which I'll put in the chat, which enables you to look up your country to work out what the relevant legal obligations are. Now, if CEDAW is signed and ratified, and if the optional protocol is in place in the country that you're working in, then the fact that CEDAW doesn't have a jurisdiction clause, that it takes a broad effects-based approach to jurisdiction, means that you can rely on the convention's protection to cover the second part of your situation, so women and girls who are on migration routes. So actually their rights are protected because of the broad effects-based approach to jurisdiction that the CEDAW committee takes. The other really interesting thing about CEDAW is that, unlike other international conventions, like the ICCPR, for example, CEDAW doesn't distinguish between the rights held by migrants and other women who are in a jurisdiction. In fact, more than that, it takes a very strong intersectional approach to women's rights and argues that migrant, refugee, and internally displaced people have to be provided with additional special protections, and that the migration status of someone cannot be used to deny them, for example, essential state services like healthcare. So the first step to using the CEDAW Convention is working out whether its protections of migrant women are available to you in the jurisdiction that you're working in. Once you've done that, it might be interesting or useful to engage with civil society organizations who are taking part in the shadow reporting process. So there's another question in the chat which talks about how general recommendations are enforced and whether they're enforced. And they are through a process of dialogue between the committee and the state. So every 4 years, each state party has to report on its progress in implementing the convention to the CEDAW committee. And the committee will review that recommendation, will also take soundings or receive information from civil society organizations. And through this reporting process, states are held to account for the specific content of general recommendations. Now, you can use that reporting process to highlight areas where states are violating convention rights and to put pressure on states when they give evidence to the committee to improve their practice on the issues that you're concerned with. And having said everything I have about the individual communications procedure, I would still encourage individuals who think that their rights have been violated under the convention to use that, because I think that the geographical skewing of complaints is one of the issues that is really plaguing the committee at the moment, as well as issues around legal advice and representation. I think if we want to improve the committee's adjudicative role, then we have to ensure that there is a diversity of states who are held to account through that process, and that we don't have this Eurocentric bias and this bias around particular types of issues which are raised before the committee time and time again unsuccessfully. And then very quickly on the best practice, I actually think that General Recommendation 32 sets out best practice. I think it's a really comprehensive and strong guide to what states should be doing to protect migrant women through refugee, state and statelessness determination procedures. And after that, I look at General Recommendation 35 on gender-based violence against women. I think the issue isn't that we don't know what best practice is. The issue is that we're not effectively holding states to account for their failures to discharge their due diligence and other obligations to migrant women, protection-seeking women, and women who are at risk of gender-based violence.
Fantastic. Thanks, Catherine. And then we have a question for Lotte and Brandy. So Andrea is asking, which steps do you think are needed for authorities deciding refugee status applications to be able to better determine credibility? Would training of the authorities help, or do you think a new law or significant jurisprudence in this area is needed?
Thank you for your question. I will start us off today and then I'll pass on to Brandy. So it's a really good question, and I really like this kind of practical aspect of our research. So in Australia, there have been recent changes in the way that the Department of Home Affairs kind of does their work in terms of determining refugee status. So there are trainings that have been implemented, and there are actually new guidelines on how to determine credibility. And our research found that it has made a difference to some extent. For example, there was one worker from the Department of Home Affairs who always wears an LGBTI flag as a badge, kind of signaling to people that they're safe to open up about their identity. However, we also found that this is really not enough. So the guidelines are, while they exist, they're inconsistently used, and they don't really address the issue of knowability, which is fair enough. But so I think, some practical things that I've been thinking about is teaching decision makers kind of that they need to be aware that there is an infinite range of sexualities and genders, and you could never really know them all. So kind of opening up people's minds to this idea that sexuality and gender and all identities are fluid. They can be changing, and you can't necessarily come in with a set of stereotypical ideas, because people will always fail to live up to that standard. So teaching decision makers how to kind of listen openly, allow for inconsistencies in people's stories about their identity labels, and kind of look beyond that. One other thing that we found is that, allowing the applicant to use a label in a different language, the two examples that we gave, or use no label at all, kind of allowing for that. And kind of going through this process of teaching decision makers about their own biases and that identities can evolve and change over time. So in Australia, there's a huge backlog of refugee interviews that basically haven't been done, and the process can take 6-7 years. And so one really practical example is that often the person's identity label might change over time, but that doesn't mean that they haven't genuinely experienced persecution for being LGBTQ. It just means that they can't necessarily fit into this expectation that they have an identity label, and that kind of comes with them throughout.
Yeah, and further to that point, I think Lotte has the positive view that we can, in some ways, change the mind of the adjudicators. And while I like that idea, and I like the sort of positivity that Lotte brings to the work, I think sometimes it's so how do we train somebody? I don't know about RSDs in other countries as much here, but it's not as though the refugee status determinator, the adjudicator here, has necessarily any kind of particular type of background, particular kind of work that they've done in the past. It's a political appointment to a certain extent. So there's also kind of an understanding, perhaps, why I wouldn't say we need a new law, because I think when we start talking about new laws or new aspects of jurisprudence, it starts to get a bit we don't want to take away what we have, right? But I think we need to think a little bit more about who is chosen and more of a process around those adjudicators, and not just trying to train the ones that are there, which are majority straight white men. Instead, trying to say, let's open up this space to different kinds of adjudicators, and adjudicators with the kind of background that we would want to see to have an understanding of asylum seeking and refugee experience in a different way than what we currently see about who's appointed to that. Thanks a lot.
Yeah, thanks so much. That's really interesting. And I think all of your answers and talks in some ways, right, speak to that question of what do we do with border discrimination more generally, right? Because I mean, we've learned from the papers, it seems, right? I mean, we knew that before, but I guess you drew it out in very interesting ways, right? How the border works through discriminations of race, let's say in Rui's paper, right? Sexuality and gender in Lotte and Brandy, gender in Catherine, or language and access to the digital in Anna's. So the question is, can we work with border discrimination, right? Can we borders make less discriminatory, right? And have better policies, better laws, better strategies? Or are we working with, right, a system that is not broken, but it's like violent in itself, right? Where that discrimination is part of it. So we need to think of potentially different imaginaries. So thinking back of the keynote of Harsha Walias and the kind of more abolitionist frames that are coming up in critical migration and border studies. So I was just wondering what your ideas are, if any of you are working with these frameworks or coming from the very kind of practice, right? Kind of activist or legal context also of trying to make these improvements. What do you make out of such more kind of utopian or radical projects, and how you would think them in relation to border discrimination? Whoever wants to have a go, go first.
I'll talk to it very briefly, and then I'll let somebody else who does practitioner work, discuss that. But I think in the same breath that we discuss how, there's issues around, prisons and our prison society, that the entire idea of securitization around our nations, within our nations, and this idea of state sovereignty somehow being, the most central thing to our understanding of the world and how we relate to other countries, and this increasing, kind of borders being not just a geographical line on a map, but being pushed out farther and farther into other countries, into other spaces, is that we kind of need to take a more critical approach. We are, I think, as you said, Billy, working, studying within a system that's broken and which is violent, and which is purposely, especially in the Australian context, but I would argue everywhere else as well, is about the, the exclusion of the other and the exclusion of, those people that could be seen as sort of threats, or, or some way we can put them in as threats within that. So, yeah, I thought the keynote was really good around that, and I definitely have a lot of that. We haven't done much writing on that, but I think that was really good to bring in. All right, I'll be quiet now. Thanks.
Bill, I would like to say something, because this is a kind of question that makes me thinking about the human history until now, that we are in the 21st century. And I'm not 100% legalist with the laws, but I think that we reach now laws that can be in the praxis more effective if the people that are in charge too could have another sensitivity with the others. But I can say that this is so complex because we are talking about a complex of the groups of ideas, that liberalism, neoliberalism, a lot of dichotomy, less exploitment, more exploited. We are talking about phenotype, how the people characterize themselves. It means, for your questions, I think until we are not recognized the others as they are, will be very difficult to tackle discrimination. I will say to conclude, discrimination will not end. Will be until the women's will be here. Discrimination, the way I define discrimination, the race in my paper, will be alive in our. I could ask for me myself. I discriminate to the others. For my experience as a policymaker, advisory, it was very difficult to work with cultures that I didn't have any contact. And then I have to recognize myself also and to make what Connor West said, paideia. This idea, the paideia, education through the conflict. This idea, the paideia education is not just a theory, but also how I can, as a human being, in this moment of the history, can transform myself in my relationship with the other according to the law that we have, and according with other principles and morals that makes that we, since the Greek times, that we have. Because democracy, we have democracy because is the best system to tackle these kind of questions about discrimination or inequality.
Right, cool, thanks. And I think Anna, you had your hand up too.
Yes, thank you, Billy, and thank you, Rui, for that answer. I very much feel that it has to do with everyday discrimination practices and everyday borderline. And for example, lots of or many of the women of the group I work with are cleaners, for example. And I think we as Latin Americans working in a role as cleaners face, for example, double invisibility, you know, because it's not about just, as I mentioned, the Latin American ethnicity here in the UK is not recognized as an ethnicity. The role of a cleaner is very much overlooked. So for example, when we went into the first lockdown here, when it was all about the frontliners and celebrating them, the cleaners were not recognized as a frontliner explicitly. So for example, they couldn't not access any of the benefits that came with being a frontliner during a pandemic, a cleaner, which of course is a very important role with what's happening. So I think it's, at least from what I've worked and our group, I think it's all about the microaggressions, you know, and how it's just like day by day that that basically very much eliminates your confidence, you know, your trust in yourselves. For example, I think that's why English is so difficult, you know, because to speak English, you need to trust in yourself, you need to be confident, and you need to know that your voice matters and that you're going to be heard. But if that's not been the story in the past, or if before I haven't been noticed, like that's something that just adds up. And it's difficult. It's a lifetime of being invisible, which I think it's very difficult to overcome.
Yeah, very important, thanks. And then let's have some last ideas by Catherine, and then I'm afraid we also have to wrap up. We're coming to the end of the time.
Thank you. When lawyers talk about discrimination, they're talking about something that's quite different from how people refer to discriminatory practices in everyday conversation. We're talking about unjustifiable differential treatment on certain protected grounds, including race, sex, gender, or sexual orientation, for example. Conventions like CEDAW, or the Convention on the Elimination of All Forms of Race Discrimination, give lawyers and activists really important tools for challenging forms of differential treatment at all stages in the migratory process that produce some of the forms of violence and death and unequal treatment and experiences that we are concerned about. And I think one of the things we have to ask ourselves if we're involved in the practice of discrimination law, or if we're interested in it, is why these migration control practices have gone unchallenged by discrimination lawyers for so long. We're very familiar, for example, with discrimination law being applied in the workplace or in other domains, like when we're trying to access services, for example. And I think that the question as to why these hugely discriminatory practices that don't survive legal analyses have been so consistent and enduring is one that requires further examination. Now, when I say this, I'm not being blind to the faults of discrimination law, and I can't kind of summarize them in any way now, only to point you to a brilliant lecture by Dr. Shreya Atre as part of the Current Legal Problems series on race discrimination without racism. And she sets out very clearly what some of the problems are with using discrimination law to challenge structural or systemic forms of injustice or violence. But I would say that discrimination law gives us the tools to render visible some of the identities and some of the forms of harms that we have and that we are concerned with on this panel and across the conference as a whole. And once you've done that, once you've rendered something visible, you can start to unpick it, you can start to challenge, and you can start to do justice to some of the forms of harm that we have discussed. So thank you.
Fantastic. Thanks so much. Yeah, I think we're at the end of the session, right? I'm not sure exactly how. Sarah here? No? What exactly? Yeah, there you are. How strict we are on time, or what's happening. I guess we could go on forever, but I guess this could be a nice wrap.
I think Catherine concluded very nicely, so I will just continue with my few concluding remarks, and then I will all leave you go to your deserved lunch break, at least if you're in Europe. So first of all, thank you so much to everyone for attending. Thank you for the panelists for preparing such thought-provoking presentations. And of course, thank you to our chair, Billy Holzberg, for moderating. I really liked how at the end during the Q&A session, you tried to tie the different ends of the conference together and speaking again of the keynote of Hashawalia. And while I have really no capacity of summarizing these engaging discussions, and as Catherine was just saying, discrimination in legal terms is also something a bit different from what we commonly understand in everyday language. In discrimination, I do think that your different presentations all spoke to each other, and they all somehow spoke to the fact how identities of refugees and migrants, just as everyone's identities, are really fluid and complex, and what harm is being done when this is not appropriately recognized. And if the identities of refugees and migrants are not being recognized as they present themselves, if they don't fit certain narratives. And here I just wanted to flag the next panel that we will have this afternoon, Borderlines, Bordering, Border Diffusion at 5 p.m. British Summer Time, because I think it really ties in nicely with the discussions that we had this morning. It will be chaired by Samuel Singler from Border Criminologies, and we have an engaging range of speakers who will all somehow speak again to this narrative, how borders are much more than borderlines and borderlands, how borders follow people away from borderlands, and how borders are being performed, incorporated, and resisted. And I'm really looking forward to seeing you there. And if you're enjoying the conference so far, please consider making a donation, which can be done through purchasing a donation ticket on our Eventbrite page. Your donations will be split among 5 organizations that are each contributing to the conference week. And maybe some of you have already seen them yesterday at our activist and practitioners panel, namely Outro Streams in Action, Border Violence Monitoring Network, State Watch, Oxford Against Immigration Detention, and OutConnects. I also wanted to take a minute to thank the co-hosts of this conference, Rounded Magazine, Border Criminologies, and the Oxford Migration Mobility Network, and of course, the whole team of the Oxford Migration Studies Society. Thank you to Bella, Philippa, Charlie, Jasper, Guadalupe, Trin, Magda, Sahir, and Nathan. Do be sure to follow along on our social media for information on the rest of the conference week, and we hope you'll be virtually joining us again soon. You can still register for all upcoming events on Eventbrite, but the Zoom link is the same for the entire week, so it should be fairly straightforward on joining. And if you've not already had a look, and I think Rui has pointed several times to this during his presentation, the conference special issue is also available on the Routed website, and I would really encourage you to engage with the articles from our speakers. Finally, the conference recordings will be published on the Border Criminologies YouTube account, so we can all go back. Take care, and thanks again. See you this afternoon.